Welcome to Chapter 5. In this chapter, we're going to discuss affirmative action. It's important to understand the legal requirements of affirmative action plans, but also to hopefully correct any misinformation you might have heard about this issue over the years. At the end of this chapter, hopefully you have a good grasp on what affirmative action is and what it's not, what the law requires in order to institute different types of affirmative action plans, and what their role in this area is for you as a future leader, manager, supervisor in a business. So before you really begin jumping into this topic, I want you to kind of think about what you've heard about affirmative action. What do you think affirmative action is? Because sometimes what I found is often what students have heard or think they know is sometimes incorrect. So think about what you've heard or what you already know about affirmative action as you go into this chapter to help understand what the law truly says it is. And then at the end of this chapter, you'll understand kind of more of the reality of the law, and it might be different from some of the misconceptions that you have heard or maybe that you yourself have believed in past times. The learning objectives for this chapter include, discussing what affirmative action is, why it was created, providing the results of several studies indicating why there continues to need a more than passive approach to provide equal employment opportunity, naming and explaining 3 types of affirmative action plans, explaining when affirmative action plans are required, how they're created, listing the basic safeguards put in place in affirmative action plans to minimize harm to others, defining what reverse discrimination is and how it relates to affirmative action, explaining and reviewing current legal challenges to affirmative action, explaining the arguments of those who opposed to affirmative action and those who support it. So it's important to understand both sides of those arguments, and explaining the concept of valuing diversity and inclusion, access, and belonging, and why it's needed in a workforce, and examples of ways to do it, like in your management tips. So let's start off. What is affirmative action? The idea of these affirmative action plans is the intentional inclusion of groups of people. Typically it is being applied to like women and minorities in the workplace, but based on a finding of previous exclusion. So it doesn't apply just universally. We're looking at situations where there was a finding of exclusion or discrimination that ordinarily, these groups would not be excluded were it not for, the situation where there's been discrimination or its vestiges that have been found to be at place. And it also can include and apply to individuals with disabilities and veterans, sometimes also are included as part of a specific affirmative action plan. And so it's going to apply on a case-by-case basis. This is the legal basis for affirmative action. We have Executive Order 11246, Civil Rights Act. I'm not going to read through these statutes, but they're available in the slides. But it's important to recognize that there's a lot of talk and rhetoric about the concept of affirmative action. And a lot of it sometimes is based on misinformation or mistaken assumptions, but there are very clear arguments for and against affirmative action. So the important thing in this chapter is kind of to filter through some of the misconceptions and mistaken ideas, but to get to the heart of what these plans exist for, what their purpose is, what are the arguments for and against them that are actually valid and based in what the law is. A lot of the angst and frustration that is in opposition to affirmative action plans is related to race, but the statistics actually show that white women have actually had the most to gain under affirmative action plans. And, there's a lot of confusion and misunderstanding with affirmative action that makes it easily a target, and that it's been imposed. There's certain duties that are not actually there. Like, this job has to be held for this category of person. It's an immutable characteristic, and that's not necessarily the case. It's important to remember that individuals with disabilities and veterans are also covered by some of the affirmative action provisions. And again, like in this chapter, it's important that the focus is not on personal philosophies. It's important that you all have your own individual personal perspectives. But for the purposes of this chapter, it's important to look at the legal context. What is required of employers? What does the data show? What does the statistics mean? And that kind of stuff. So when it comes to affirmative action, there are specific tactics that an employer can use to help prevent having a problem that would require a finding of needing an affirmative action plan. If an employer is making sure that in their recruiting practices they have a large outreach and they're recruiting to lots of different groups, to get the best applicants, to find the best talent, opportunities for mentoring and management training and development of groups as they're coming up in the business. Again, like, these will cast a wide net and create a large pool to draw from for talent and finding the best possible candidates for leadership and positions in a company. And hiring, training practices, other attempts to bring workplace groups that have traditionally been left out of the employment process. We have certain cultural stereotypes or things in society where different groups have been left out of different types of careers or positions. And again, programs that will widen the net to bring in maybe groups that have traditionally been left out of certain employment categories helps to create more of a diversity in that workforce, just naturally, and has nothing to do with a legally mandated affirmative action plan. So here we are, in a time where we are 60 years removed from the large legislation that came through the civil rights movement. And yet there's still research that shows some challenges that need to be overcome. A lot of the research is, listed in your textbook, with footnotes, but just to kind of cover some of the highlights here, women and minorities still lag in terms of, pay, jobs, promotions. The absence of these groups generally stems from attitudes about or actions toward groups that resulted from absence in the workplace or presence in really low numbers that are at odds with their availability in the workforce. This absence might have just likely come from letting the status quo continue. It's not necessarily always due to like any kind of negative feelings or intentional discrimination, or even having thoughts about groups that have been excluded. It's just that, the treatment of these groups that have been excluded in the past, in history, it was easy to kind of continue on with a system that had, virtually a homogeneous environment. It didn't include these people that were in excluded groups, or it was only including people on a limited basis. So again, not really reflecting the availability of people in the workforce, people that are, going to school together, living in neighborhoods together, socializing together, that kind of stuff. And so the correlation to that is when it's time for someone to hire, there's an opening at their company, or they've got to bring people in, they might have networking connections to people that they are already socializing with, already live near them in their neighborhood, or again, socialize with them in organizations and clubs or churches, or grew up together, or went to school together, that kind of stuff. And so people tend to hire those that are familiar to them. So inevitably, this means exclusion of people that are not considered part of that environment, part of that group. And so again, this can stem from social exclusion, people that they don't have an interaction with, but it's a problem if people are only hiring, people that they're coming in contact with without exploring the opportunity to cast a wide net and find the most talented and available people to hire. And so change occurs when people make efforts to do things different if they want change. And that's what some of these affirmative action plans are really about, trying to change what has been done and might continue to be done without an intervention. The 100-year period between the end of the Civil War and the passage of the Civil Rights Act kind of shows when little or nothing is done to intentionally try to impact matters, things don't change very quickly. They tend to kind of stay more status quo. And that's another reason why in your textbook you'll find these little slice of life boxes that I really like to kind of give you an idea of what life was like when some of these laws were created. It's hard for us to imagine, because of the time period that we're living in now, what it looked like without these laws before Title VII, and so, especially. And so looking at those little slice of life boxes are helpful to kind of get a glimpse into history of what things were really like for some of these groups. But again, back to the research findings for today, we still have groups that through immutable characteristics that they have no control over are still lagging in some of these measurements. And they've even done studies where with fake resumes and skills and how that affected employment. You've heard that term, breaking through the glass ceiling. There has been a lot of progress with these, breaking through these boundaries that existed in the past. And yet there's still a lot of room for improvement when it comes to specifically to women and minorities. The Federal Glass Ceiling Commission had this study and said that women made up to close to half the workforce, but only had 5% of these top-ranking jobs in companies, and African Americans and other minorities account for less than 3% of these top jobs, and yet they make up a lot more of that workforce. So we've talked about the requirement for an affirmative action plan. So how do these obligations arise? Well, there's 3 ways that affirmative action obligations can arise. We have situations with federal contract. So these 3 ways, we have executive order covering federal contractors. So those are people that give, goods and services to the federal government. The second way is affirmative action obligations could arise judicially as a remedy for finding discrimination under Title VII. A lot of times people automatically think that affirmative action is, this automatic part of Title VII that protects against discrimination. And in fact, Title VII has an affirmative action, remedy component. But affirmative action actually really stems from, more from this executive order than it does through Title VII other than as a remedy. And then third, we have some affirmative action obligations sometimes that are voluntarily implemented. They're established by an employer or union through some kind of like agreement or something that they come to. Starting first to look a little bit more closely at those 3 areas, starting first with the Executive Order 11246. To rewind a little bit for your history lesson, before we had this executive order, we had Executive Order 8802, which was signed by President Franklin D. Roosevelt in 1941. And it specifically applied to defense contractors. It was issued to fight against discrimination during World War II, and the design of it was to help promote successful conduct of the national defense effort to produce, defense supplies to help in World War II. And there were several changes that kind of went into play before the present version that we consider now, signed by President Lyndon B. Johnson in 1965 as a presidential executive order. And so this requires government contractors to, remedy any kind of discrimination or evidences of past discrimination in their workforce in order to participate in these government contracts. And further, in addition to prohibiting discrimination in employment, they need to make sure they're taking steps for adequate representation, and the compliance requirements are for those who have these contracts that are $10,000 or more. It also applies if, a contractor or subcontractor has 50 or more employees. They have a greater than $50,000 or more contract. The contractor has to develop a written affirmative action plan for their establishments within 120 days of beginning the contract, and those contracts under $10,000 are exempt from that particular compliance. And more recently, those regulations have also expanded to include disabled individuals and veterans in these contracts. So to just briefly talk about what these kind of requirements look like, they're asking these contractors and subcontractors to agree to post in like a conspicuous place notices setting forth the provisions of their non-discrimination policies. They include in all their solicitations or like advertisements for employees a statement that all qualified applicants are going to be considered without any regard to race, color, religion, gender, sexual orientation, gender identity, national origin, etc., and include a statement of those obligations in their contracts or purchase orders, and then they furnish information reports required by the executive order and implementing regulations, and permit access to their books and the records and their accounts to the agency they're contracting with or Secretary of Labor, so that they can ascertain that these businesses are in compliance with the executive order and those regulations. So under these regulations, affirmative action plans should be considered a management tool. So it's an important way of how the corporation conducts their business, encouraging self-evaluation at every aspect of employment, establishing systems to monitor and examine employment decisions and compensation systems to ensure that they're free of discrimination. So you can see how there's qualitative and quantitative components to this. Looking at the workplace to see where and in what capacity the workplace reflects the pool of available workers. Of course, the qualitative part, sets out a course of action. How do we address, underrepresentation or underutilization or any other problems that might be found after looking at, the quantitative part and analyzing the numbers and the statistics. There's also executive order prohibitions against, women, minorities, the Q+ community of employees, as well as employees with disabilities and veterans. And these affirmative action plan requirements are not going to be the same because different individuals in different categories are going to have different accommodation needs. And so when it comes to plans, some of these plans are really primarily directed at women and minorities based on the historical data that employers have utilized. And so that's where we get this, the technical plan requirements end up being primarily directed at women and minorities, because that's what a lot of these studies are reflecting, is that we just have situations where so many of these corporations, as they're looking at their workforce, analyzing it, they just don't have the representation in the workplace that statistics show of potential workforce availability and qualifications for, groups. We have groups here listed here, African Americans, Latinos, Asians, Pacific Islanders, Native Americans, Alaska Natives. Those are specific groups that keep coming up in a lot of statistics that are either not in the workplace as they would be expected to be, or are being underemployed considering their qualifications. And so that's why, like, some of the plans that have been analyzed see that they're directed at some of these groups, because that appears what is needed a lot for remediation at this point. And so part of that is going to include an organizational profile. So these employers have to prepare, this organizational profile that's like a snapshot of showing staffing patterns within the workplace. And it's one method that contractors can use to determine whether barriers to equal employment opportunity might exist in their organization. And then another part of this snapshot is job group analysis, which combines job titles in their workplace that have similar content, wage rates, and opportunities, and that information is kind of compared to the availability of, women and minorities in of those job groups. And so when a contractor has this snapshot, they understand kind of where they are, where they'd like to be, what's the difference between, who is in the workplace and the availability of the workforce that is being underutilized, and what kind of benchmarks they might establish in order to determine if there's barriers to equal opportunity that might exist. And of course, it's important to remember that availability is not just the mere presence of women and minority in a given geographic area. we're talking about the availability of groups that are actually qualified for the job under consideration. Just because an area has, whatever percentage of women in this population for a particular area doesn't mean that that percentage of women are all qualified for this particular job. That doesn't mean that percentage of women are qualified as professors or doctors or a craftsman or a manager or something. Just because the availability of jobs, for instance, managers are only going to consider the people that are actually qualified to fill that position rather than just people based on this characteristic or this class. And so that's a really important consideration, and that's where some of the misconceptions come into play, that these jobs are not looking to change what this picture looks like. The idea is you still want the most qualified talent. Are those opportunities been given? Because this whole concept is about opportunities, not about putting someone in a job that they're not qualified for. That's a misconception of affirmative action that has existed and persisted for a long time. Sorry, I jumped ahead to this slide talking about qualifications, but again, the thing isn't about, who lives in this area and what's the profile and makeup of that area. It really is about who's qualified for these jobs, and does the qualification of the workforce in that area is really the demographic we're looking at. And so based on, the availability of the qualified applicants, that's where a placement goal might come into place. Because again, it's not about all the minorities or women or whatever group in that area that are available. It's about those qualified individuals. It's not about quotas. Quotas are expressly forbidden. It's more about programs that make sense to help recruit and make good faith efforts, that the net is being cast to a wide group. So it's really important, for managers to remember, when they're making decisions, employers are expressly not required to hire a person who lacks qualifications to perform the job successfully, or hire a less qualified person in preference to a more qualified one. That is absolutely not okay, because we'll get into that a little later in the chapter. But if someone is being overlooked, even though they're most qualified, because they didn't fit this category, that is reverse discrimination, and that's still discrimination. We call it reverse discrimination because we're talking about majority group, not minority group, but it's discrimination, period, to make these decisions based on someone's immutable characteristics and not hiring the person who's the most qualified for the job. So once this quantitative part of the affirmative action plan is in place, if underrepresentation or other problem is still persisting, then the contractor has to develop an action-oriented program designed to correct them. OFCCP believes that in order for these programs to be effective, they must be more than just business as usual. So they're looking for something that is different than the status quo, because the status quo might be what led to the underrepresentation in the first place. So they can perform these audits of a contract to determine if they're complying with the regulations, if they're providing equal opportunity for employment. And so part of this action plan, they develop and implement internal auditing systems. They're going to require internal reporting on a scheduled basis, relating to equal employment opportunity and organizational objectives, review report results with all the levels of management, upper and lower management, recommending whatever improvements might be needed, advise top management of the program's effectiveness, submit recommendations for improvement if necessary, and all this kind of in an effort to combat the glass ceiling. These regulations also require corporate management compliance evaluations that help determine whether employees are encountering artificial barriers to advancement at mid-level or senior level kind of promotions, because some of the statistics in our current employment situation are showing that for some of these groups, the studies have shown that it's easier for women and minorities to enter a business at like an entry level, but something is still affecting progress up, like promotions and higher level positions once there. And so this is a tool that can be used to address this phenomenon, to find out what barriers might be preventing upward mobility in a company. And so again, like, it's important to remember there is no requirement for quotas under the executive order or under Title VII. And in fact, specifically, the law says it should not be ever interpreted as such for quotas. So virtually the only time quotas have ever even been permitted, it's limited, very limited circumstances, is when there's been long-standing violations of the law and it becomes like a last resort kind of recourse. So there's a few cases that you'll see where that exists, but it's, again, very rare and kind of a last resort kind of thing. But there are penalties for non-compliance. And so the appropriate, contracting agency can impose an employer the penalties for non-compliance. And those penalties could include publishing violation information and the names of who's non-conforming, recommending Title VII proceedings, like in the Department of Justice or the EEOC, requesting suit to enforce the executive order in cases of actual or threatened substantial violations, recommending criminal proceedings if that's a situation where there's been false information supplied, so they're lying about their compliance and an audit has discovered they're not complying the way they said they were, or canceling, terminating, suspending the contract, portions thereof. And when it comes to these government contracts, something that maybe many of you may not be aware of, but government contracts can be very valuable to certain business interests and entities. And one of the biggest reasons is government pays their contracts. Sometimes in other situations, it can be hard to collect from someone that you're doing business with, and these government contracts are a good opportunity for growth and guaranteed payment for the contract and stuff. And so there's a lot of businesses that really want to get these federal contracts. It also can create stability for long-term relationships. And then in the rarest cases of noncompliance, the contractor can be prevented from getting future work with the government. And then fines for noncompliance can reach into the millions. Okay, moving on to the second kind of way that affirmative action plans kind of come into play is with a judicial affirmative action plan. So this is where a company is ordered by court because they've had a finding of past discrimination through some kind of lawsuit or claim, and the discrimination is found by the court that has occurred rather than coming through this government contract branch with executive order. And a judge has ordered an affirmative action plan put into place. This is an unusual remedy. And it's important to remember that, Title VII gives courts a pretty big range, a spectrum of how they can address or redress wrongs in discrimination cases. But when a court is ordering an affirmative action plan as the remedy in a case, we refer to that as judicial affirmative action. I have a few cases listed here that kind of illustrate these from your textbook, but one I'd like to just talk about for a minute is the Local 28 sheet metal workers case versus EEOC. And you'll find that at the end of your chapter, but the court imposed in this case one of the more, stiffer judicial affirmative action plans. But it came after the court's orders had been repeatedly ignored by the union. So as you look at this case, I want you to kind of look at that timeline. And so, the Supreme Court held in this case that, after the original finding, of discrimination happened in 1964. So the Local 28 case in 1989 was decades later. So they had all this stuff where, the sheet metal workers were keeping Blacks and Latinos out of this union. And so I don't want you to miss the fact this happened in New York, which we tend to think of as a more diverse community in New York. And yet this case kind of demonstrates why Title VII applies, not only to employers, but to unions and other organizations that are in that employment context, because we have a situation where, this is the kind of situation that justified this action. As you read the case, think about what the employer or the union, should have done could have handled the situation, well before it got to that point. So the third kind of type of affirmative action that someone might see or be part of are affirmative actions that are on their own. They're not compelled by the executive order requirements or a court order because of, having problems with discrimination in the past. These are situations where employers are engaging in some kind of voluntary effort, like a proactive measure to make sure they're avoiding discrimination claims and avoiding discrimination by making a determination and self-evaluation on their own. And so there's strict guidelines. It's really important that strict guidelines are followed if a plan is able to withstand legal challenges by an affected employee alleging discrimination because of this plan's implementation. So it's important as someone is trying to voluntarily adopt procedures and processes in a company to help make sure discrimination is not going on, that they do this in a way where it creates a balance of helping to avoid discrimination claims in the future, and also not trampling on the rights of majority workers or creating problems for their advancement. Because again, it's discrimination if it is making these decisions that hurt people based on some immutable characteristics that don't have anything to do with their actual qualifications for the job. So it's really important to not, if it's a voluntarily administered plan, to try to seek more protections from getting sued for diversity claims or creating those claims to begin with. That some of these things are kind of points to make sure that there are not positions set aside for any groups. I use the example of women and minorities because that's what we see a lot in the statistics as quotas. Quotas are not okay. Almost always. They're, again, very narrow exception. Goals are not quotas. That's different. But making sure these plans are temporary. When a goal is reached, the plan ends. Again, plans to protect against discrimination, and that also should include again, balancing, preventing discrimination and also preventing reverse discrimination. And they need to cause only minimal intrusion into legitimate settled expectations of other employees that already exist in the workplace. And so again, these are, the points I just kind of covered. They don't unnecessarily, trammel the rights of majority workers in that situation. Positions are not set aside or reserved for people just because they check this box, a particular category, to meet a quota. And again, temporary programs and goals. When a goal is reached, the plan ends and should only cause minimal intrusion into legitimate settled expectations of other employees. So we want to have that balance and not affect those kind of things. And I've mentioned this previously, but also discussing reverse discrimination is important because we call it reverse discrimination because we're talking about the majority of the group, not minority member of a group. But it's important that, again, if someone is facing an adverse employment decision based on these immutable characteristics, that is not okay, and that is discrimination that is protected against by federal law. So when you're thinking about this, think about, there's always that flip side of the coin. When an employer is taking something like race or gender into account, even if they're trying to think of it as, in terms of a goal that is a good goal, they have to be really careful not to exclude someone in a group and cause harm to someone in this excluded group. So, it, again, isn't something that accounts for a ton of the claims, but it's still something that continues to create claims for discrimination about 3% of the time in the EEOC charges. It, again, has a low rate, but it still exists, and so this is something that's important to be aware of. And the problem, what the reality kind of shows in practice, is that this misunderstanding stems from employees having a fundamental misunderstanding of discrimination laws, how they operate, what affirmative action really is, and how they intend to do it. So as you're taking this class and you're learning these things, these are kind of the things you can take into your future careers to help educate people around you and help prevent these kind of situations in the workplace. That, this legislation under Title VII and other protective legislation, it protects everyone. There's no special provision for this category, that category, everyone is protected in a way that they should not be discriminated against. Everyone's protected by the law. And that law provides protection and remedies for proven discrimination that harm other people. And that's important to consider. Again, the idea is that no one's getting discriminated against, and the best talent and the best skills are the people getting the opportunities. So switching gears a little bit, it's important to talk about companies and culture that has the opportunity to value people that come from different perspectives and different backgrounds, and valuing diversity, coming to appreciate people who are different and have value in their contributions in the workplace. So when we talk about diversity, we're talking about the difference in composition of the workplace, and inclusion relates to the value, the strategic business value that comes from valuing some of that diversity. And this is a little bit different. It comes into play, beyond affirmative action plans and those kind of things to help give people opportunity that were previously excluded. But it's also about companies offering a place for belonging and valuing multiculturalism to keep employees in the workforce that were previously excluded, and allowing them opportunities to progress in the workplace. And so here's a little illustration of, sometimes things that are, the difference between like fair and equal, or equality and equity. In the first image, we have 3 blocks where 3 people are standing to watch this game. And it's assumed that everyone's going to benefit from the same supports. They've got the same size little blocks they're standing on. They're all being treated equally. In the second image, individuals are given different supports to make it possible for them to have equal access to the game. So they're being treated equitably. In the third image, all 3 can see the game without any supports or accommodations because the cause of the inequity was addressed. The systemic barrier has been removed. So we have, a privacy type fence where they need blocks to stand on to kind of see over it, versus having a more transparent fence that doesn't affect the view. And so that illustration is kind of an example of looking at, the need to move to that direction where the cause of the inequity was addressed, that systemic barrier has been removed, and so we no longer need to make different accommodations for individuals to give them that same opportunity. And that's kind of the goal. So moving into management tips for this chapter, or this content. As we wrap up this chapter, the management tips are kind of, the important thing that you can take with you as you go into your future careers. And of course, we're going to remember that affirmative action can be tricky. Keeping these kind of tips in mind can help you support a corporate policy and culture that can help you avoid liability for instituting or implementing any kind of affirmative action plan. The best thing to start with is practice prevention. Ensure that hiring, promotion, training, all these processes are open and available to like all the employees in a good way, and you have them available to everybody as appropriate. Know your workforce. If there's an imbalance, collaborate to see how that can be addressed. Work with a union if there's a union, or other employee groups to try to ensure fairness, and have approval from constituencies affected to make sure you ward off potential problems and get different perspectives. If there is going to be a voluntary affirmative action plan adopted, make sure it complies with all the judicial requirements. Remember those things like, making sure that it's only being used to redress a conspicuous imbalance in historically, job categories where people have been excluded. It needs to be moderate, flexible, and gradual, and temporary, and make sure that it doesn't trample on other employees' rights or create some kind of bar to their advancement. So we want to make sure both sides of the coin are addressed when it comes to helping groups that were previously discriminated against and not discriminating against other groups in the process, and prevents only minimal intrusion to those legitimate settled expectations of the employees that already existed at the company. Provide training about any kind of plan if there's going to be a plan adopted or new processes adopted so that everybody understands the purpose, the intent behind it. Make sure that you're addressing any kind of fears or anything, and commitment so that people are less likely to misunderstand or react adversely to it. And, implementing like good training into the corporate culture and the situation so that people can understand what this stuff is and is not. What is inclusion? How do we value people that come from different backgrounds and have different perspectives? How that leads to more creative solutions and those kind of things. Making sure that's included in, training, and that statistics show that there's a lot of value in that, in research, and how to deal with coworkers if there's issues that arise because of differences in culture among workers. Have good training that provides opportunities on how to handle that and how to deal with those things. So in summary, affirmative action plans are plans that intentionally include people that have been traditionally excluded from workplace after demonstrated underrepresentation of these historically disadvantaged groups. So again, it's a plan because of a problem that's been discovered through like an internal audit, or someone has a finding of a claim of discrimination. They can arise voluntarily to prevent, a discrimination lawsuit if there's a problem that has been found, or it can be implemented, in order to make sure that employer is following the responsibilities required to be a government contractor or subcontractor. And of course, understanding the historical background of why affirmative action came about in the first place, and how to avoid those pitfalls of implementation that are not going to work or might hurt someone else's rights by trying to help a different group. Employers should conduct periodic equal employment opportunity audits to monitor their workforce, just to see if there is potential problems for claims, because it is better to fix a problem before it becomes a lawsuit. And again, the research shows, current research shows, that there's still some issues with barriers in employment. And so finding those, if they exist in your workforce, is a good leadership skill to have, to understand the composition and anything that might exist, to get us more like that illustration in the picture, where we're removing barriers and then not having to worry about providing accommodations because the barrier's been removed. And of course, remembering those plans should not displace someone and put them in a position where they're not qualified. We're not talking about quotas. No one should ever hold a place for someone who checks a certain box. Having a well-reasoned, flexible plan that's supported by all levels of management will help in greatly diminishing some of the negative and misunderstandings and things that surround, and it also can help protect against lawsuits. And some of these concepts, diversity, equity, and inclusion, specifically like DEI as an acronym, is something that has a lot of political rhetoric tied to it, and that's not something we're getting into in this class. But the concept of valuing different perspectives and different people, and the creative solutions that come from having access and belonging in a workforce, have statistically proven to be beneficial to companies in their success. And so helping to create a workplace that is managing that environment, and providing opportunities for people from all different walks of life and different backgrounds, and valuing multiculturalism, is a proven benefit to companies. And so that's what we're talking about here, and that kind of stuff, and helping resolve issues before they result in litigation. And that's about all for Chapter 5. If you have any questions, send me an email or let me know. And I hope you're having a great week.